Thinking about forming an LLC in Nevada to avoid California's high taxes and regulations? Before you make that decision, you need to understand the realities of operating across state lines. Many California business owners believe they can save money by incorporating in Nevada. This misconception stems from Nevada's reputation for low taxes and business-friendly policies. However, the truth is more complicated and depends largely on where you actually conduct business. The most important factor isn't where your LLC is registered, but where you're actually operating. If your business is physically based in California, you'll still be subject to California taxes and regulations, regardless of where you incorporate. California imposes an 8.84% corporate income tax, ranking 40th in the country for corporate tax friendliness. Meanwhile, Nevada ranks first with no corporate income tax. This stark contrast leads many business owners to consider Nevada incorporation. However, California taxes any income generated within its borders, regardless of where a company is incorporated. This means a Nevada LLC doing business in California must still pay California taxes. At minimum, you'll owe California's $800 annual franchise tax, even if your LLC is registered in Nevada. Beyond taxes, incorporating in Nevada doesn't provide the legal protections many business owners expect. To receive legal protection in a state, your company must be properly registered to conduct business there. A Nevada LLC operating primarily in California without proper California registration is legally vulnerable. Without proper registration in California, your Nevada LLC cannot pursue legal action in California courts. This means you might be unable to collect debts, sue for damages, or pursue infringement cases in the state where you actually do business. Regarding privacy, Nevada does offer greater confidentiality by not requiring LLC owners to list their names in public records. However, if your Nevada LLC operates in California, you must register as a foreign entity and comply with California's disclosure requirements, negating much of this privacy advantage. Operating an LLC across two states significantly increases compliance costs. You'll need to maintain registered agents in both states, file annual reports in both jurisdictions, and comply with two sets of regulations. For a California-based business, these additional costs often outweigh any potential tax savings from Nevada incorporation. Nevada does provide strong asset protection laws, including charging order protection that prevents creditors from seizing company assets. However, these protections may not fully extend to businesses primarily operating in California, as California law will still apply to many aspects of your business. The annual costs also differ significantly. California LLCs pay a minimum $800 franchise tax annually, plus additional fees based on gross receipts for businesses earning over $250,000. Nevada LLCs pay lower fees, including a $150 annual list filing fee and a $200 business license fee. For most businesses, the practical approach is to incorporate in the state where you primarily conduct business. If your operations are based in California, incorporating there typically makes more sense, despite the higher costs. The compliance burdens and legal risks of operating as a foreign entity usually outweigh the perceived benefits of Nevada incorporation. Before making your decision, consult with a qualified business attorney who can evaluate your specific situation and help you determine the most advantageous state for your LLC formation. The right choice depends on your business model, physical location, and long-term goals.